Companies Act, Section 353, Duty of Liquidator to comply with statutory filing and disclosure requirements. Section 353 of the Companies Act, 2013 deals with the responsibility of the company liquidator to comply with all statutory obligations related to filing, delivering, making returns, accounts, or other documents, and giving notices as required under law during the winding-up process of a company. This provision not only sets out the remedial mechanism available in case the liquidator defaults in discharging these obligations, but also reinforces the principle of accountability by providing powers to the tribunal to enforce compliance and impose costs where appropriate. Section 353 also clarifies that this enforcement mechanism does not override any separate statutory penalties that may be applicable for such defaults. 1. Legal obligation of the company liquidator to file and disclose. During the process of winding up a company, the company liquidator is legally required to file various returns, accounts, statements, and other prescribed documents, deliver or submit documents or notices to authorities such as the Registrar of Companies, ROC, or the Tribunal, issue statutory notices as required under different provisions of the Companies Act or applicable rules. These obligations are essential to ensure transparency, protect the interests of creditors and contributors, and maintain proper regulatory oversight during the liquidation process. 2. Failure to comply and opportunity to rectify. If the company liquidator defaults in fulfilling any of these legal duties such as failure to file a return, deliver a required document, make an account, or give notice, the following process applies. A notice may be served on the liquidator, calling upon him to rectify the default and comply with the statutory requirement. If the liquidator fails to make good the default within 14 days from the date of service of such notice, further action can be initiated. 3. Application to the tribunal for enforcement. In case the liquidator does not rectify the default within the stipulated time, any contributory, a shareholder or member of the company, any creditor of the company, or the Registrar of Companies, ROC, may file an application before the tribunal requesting it to direct the company liquidator to make good the default. This gives affected stakeholders the ability to approach the tribunal to compel the liquidator to comply with legal duties, ensuring there is an avenue of redress in case of negligence or willful delay. 4. Powers of the tribunal to issue directions. Upon receiving such an application, the tribunal has the authority to examine the default and determine whether the liquidator has indeed failed to meet statutory requirements. If satisfied that there has been a default, issue an order directing the company liquidator to make good the default. Specify a time frame within which the liquidator must comply with the directions of the tribunal. This intervention mechanism ensures that statutory obligations are enforced within a clearly defined legal framework. 5. A tribunal's power to award costs. To reinforce accountability, subsection 2 of Section 353 empowers the tribunal to impose a financial consequence on the liquidator in the form of costs. The tribunal may direct the liquidator to bear all costs of the application made by the creditor, contributory, or registrar. This includes both the legal and incidental costs associated with initiating and pursuing the application. This provision discourages undue delay and compels the liquidator to adhere to timelines and obligations as mandated by law. 6. No prejudice to other penal provisions. Importantly, subsection 3 of Section 353 clarifies that the provisions of this section do not override or affect any other legal penalties that may be applicable for the default in question. This means that even if the tribunal directs the liquidator to rectify the default and he does so, he may still be subject to additional penalties under other provisions of the Companies Act or any other applicable law. This provision preserves the operation of penal statutes and underscores that compliance is not just a procedural obligation but a legally enforceable duty with possible punitive consequences. For more details, contact us.